Joining the Edley Center on Law and Democracy for today's conversation about combating public corruption from Watergate to now and beyond to protect and sustain democracy. I'm Catherine Lhamon. I'm Executive Director of the Edley Center. I have just a couple of housekeeping matters, and then I'm going to jump us into our panel. One is you'll see up on the slide for the panel, there's a QR code, and this is my first time that we're going to do this, but if you use that QR code, you can submit your questions. I will see them, and I can share them with our panelists, and we would love to include your thoughts in this conversation, too. And then, two, because of world events, we have, at the Edley Center, added a new event for next week, Wednesday at this time, on presidential war powers. It's timely, and you may be interested to join us for that one as well. So you can sign up on our website, and we'd love to see you there for that. Joining now for our truly expert panel, about who I'm so excited to hear from. They include a former Watergate prosecutor and also beloved member of the Berkeley instructional community, Henry Hecht, who will start us off, and then two former United States Department of Justice Public Integrity Section senior litigators who are bringing their decades of experience prosecuting public corruption to talk with us. They were with the Public Integrity Section at the United States Department of Justice until a year ago, January, and we'll talk from that experience. That's J.P. Cooney and Molly Gaston. And then, last and certainly not least, we have Donald Sherman, who is the president of Citizens for Responsibility and Ethics in Washington, whose day job is to litigate against and to educate the public about public corruption. And I'll just note that Donald and crew, his organization, filed new litigation today, challenging the federal government's effort to make it easier to fire career civil servants as a corrupt practice. So. Looking forward to hearing about that, among other issues, and that new litigation leads us to just how broad the concept of public corruption is. I want to share with you what the FBI and the United States Department of Justice say today about public corruption. The FBI website tells us that public corruption, quote, poses a fundamental threat to our national security and way of life. And the United States Department of Justice website says about public corruption that their public corruption section prosecutes cases aimed at preserving the government's integrity. So broadly understood, public corruption involves breach of public trust by government officials, federal, state, and local. And with that broad definition in mind, I'm hoping that our speakers, starting with Henry's Watergate experience, will talk to us about their efforts to combat public corruption and to move us forward. So Henry, please start.
Thank you, Catherine. Is this mic working for everybody in the back? Great. Public corruption, if you go back some 54 years, which is a little embarrassing about my age, if you go back 54 years, there was a break-in at the Watergate complex, which led to the gates, like Watergate is one, obviously, Bridgegate, and so on. I see public corruption in that period as the failure to follow the oath of office that you take, and your actions can often be corrupt. And the short version of the oath you take if you're the president is to the best of my ability to faithfully preserve, protect, and defend the Constitution of the United States. And the rest of the panel is going to bring you up to date. But starting in 1973, President Nixon did not defend the Constitution of the United States, and I think we're going to hear more about that from other speakers. The example I want to use is the Watergate break-in. 5 burglars, known as the Plumbers, they chose the name. The Plumbers was a group that said that they would fix leaks. 5 burglars broke into the offices of the Watergate complex, and it was to fix a bug they had already placed on the phone of Lawrence O'Brien, the head of the Democratic National Committee. The burglars, when caught by the police, local police, one of them had a great deal of cash and also an address book. In the address book was a phone number with the letters WH and the name Howard Hunt. Howard Hunt was in the White House and was the person actually responsible for leading the plumbers who had broken into other places before the Watergate building. I think that the system in 1973, ending up with the resignation of President Nixon in 1974, worked for 5 different reasons. The first is the system of checks and balances, which was meant to divide the government power among 3 branches to prevent any one branch from becoming too powerful. Second, there was Congress, and it actually worked. The Senate created the Senate Select Committee on Presidential Activities, and that panel was televised, taped, and then televised in the evening on the first version of PBS, McNeil-Lehrer NewsHour. And Congress had the work of the Senate Select Committee and witnesses, one of whom, as a tiny example, was Alexander Butterfield, who testified that then President Nixon had ordered a voice-activated recording system in the Oval Office. And those tapes became enormously important in the prosecution of not only the burglars, but the White House personnel that were in charge of paying hush money to the burglars, and along with that, encouraging them, or that's probably too kind, telling them how to testify and commit perjury. So I think Congress worked on Branch A, the Senate, and Branch B was the House, which had the House Judiciary Committee, and voted 3 articles of impeachment. Ultimately, that led to 3 senators going to then President Nixon and saying, "You will be impeached for sure." The president the very next day announced that he would resign his office at noon on the following day. So I think Congress played an important role. Next, the courts. Judge John Sirica was the district court judge handling the break-in case, which in our office we didn't refer to as a break-in case, but the obstruction of justice case. John Sirica ruled that the subpoena from our office for 8 tapes should be enforced. The White House took that directly to the Supreme Court. The Supreme Court voted 8-0. The missing vote was that Rehnquist recused himself, having been in the Department of Justice. And those 8 tapes turned out to be enormously important to our prosecution. So you had the district court level and you had the Supreme Court supportive of Sirica's ruling that the tape should be turned over. Next, there was why did the system work? There was the press. I hope some of you know the names of Woodward and Bernstein, or you might know that Robert Redford and Dustin Hoffman played them in the movie All the President's Men, which I highly recommend. So there was the press, and I'm including in that both the written press, as in mostly the Washington Post, but also the press in that there were 3 broadcast channels, ABC, NBC, CBS, and the beginnings of PBS. There was not a 24/7 news cycle. There was not social media. There were not people saying that there were alternative facts. And Walter Cronkite, the news anchor for CBS, was known as the most trusted man in America. So I think the press played a role. And last but not least, the public played a role, and I'll point that out in a few minutes, the role they played. We come to, I think, the next very important part. Some 5 months after the arrest of the burglars, and some 5 months after Woodward and Bernstein from the Metro desk of the Washington Post, because it was seen as a break-in to start. Some 5 months later, then Attorney General Elliot Richardson appointed the first special prosecutor. That was Archibald Cox. He had no experience as a prosecutor. He had been the Solicitor General for the United States. And Elliot Richardson appointed as special prosecutor Archibald Cox. And then that appointment became the creation of the Watergate Special Prosecution Force. Instead of us being a United States attorney, because we weren't attached to a jurisdiction, we were the Watergate prosecution force. And there was more than the Watergate break-in, but I don't think we have time today. There were more corrupt acts than just the break-in and the encouragement of false testimony and obstruction of justice. The appointment also said that the special prosecutor was independent and could only be fired for cause. And that's a really important phrase because it's going to come back to the Saturday Night Massacre, which again, I hope some of you have heard of, and I'll come to that in a moment. Our office was independent in the sense that we did not need to, not we, Professor Cox or the special prosecutor, did not need to go to the Attorney General for permission to follow anything he thought should be investigated. He should follow up as he thought best fit. And I think that's a significant difference that my colleagues will be talking about our office. Another difference than some of the investigations you now find is a combination of a witness with an infallible memory, John Dean, who had his testimony corroborated by the tapes that Butterfield had set up in the office, those voice-activated tapes. John Dean's testimony was word for word, an incredible mind, maybe not such incredible ethics, but incredible mind. And he wrote a book you might find interesting if you want to think about the dilemmas of making choices when you're 33 years old and thinking that whatever you're told to do is the proper thing to do. And I think Donald may have something to say about that. So we had a phenomenal witness, and we had the tapes, and that made a difference. Those 8 tapes that Judge Sirica said the subpoena should be withheld, the White House took that case directly to the Supreme Court, bypassed the D.C. Court of Appeals, and the Supreme Court in its 8-0 ruling said that the tapes had to be turned over and that no person was above the law. And I think that holding is pretty important. Last, because I want to respect you have a super panel to follow me, was the Saturday Night Massacre. Remember that Richardson and the setting up of the office said that the prosecutor could follow the evidence wherever he wanted. And that led to what's now known as the Saturday Night Massacre. President Nixon refused to turn over the tapes, and we'll come back to that Supreme Court decision. He refused to turn over the tape, and he told Elliot Richardson to fire Archibald Cox. Elliot Richardson said, I promised the special prosecutor that he could only be fired for cause, and there's no cause here. Rather than fire Archibald Cox, Elliot Richardson resigned. The next in the chain was Bill Ruckelshaus, who later became the head of EPA. Bill Ruckelshaus, the Deputy Attorney General, said, I won't fire Archibald Cox because there's no cause, which brought us to Robert Bork. Some of you may know that name because he was Solicitor General, the third in the chain of command, later nominated for the Supreme Court and was unsuccessful in being appointed justice. And some think his firing of Archibald Cox may have something to do with that. The massacre was only the chopping off of the head of the special prosecutor. I and all of my colleagues at the office were not fired, and some of us think that was a bad judgment by the president. I mentioned that there were other things, and in the interest of time that we investigated, I won't go into those. Last, the public, because I mentioned the importance of the press, and Woodward and Bernstein, I think, were the most important at the Washington Post. Last but not least is the role of the public. When the Saturday Night Massacre occurred, the Washington office of Western Union received 50,000 telegrams shutting down the office with no more capacity, and the vast majority of those telegrams were supportive of Archibald Cox not being fired. So that's some of the things that made the system work.
Thank you.
So again, my name's JP Cooney, and I worked at the Justice Department for almost 2 decades, and most recently, I was the Deputy Special Counsel to Jack Smith, so working on the investigations of Donald Trump for attempting to unlawfully overturn the election results in 2020 and for stealing classified documents from the White House after he left office. And first, Henry, thank you. And what I want to do is just contrast how the institutions of government worked during this last investigation of Donald Trump versus how they worked of Richard Nixon. And one thing, if you're a student of history and you want to look at this, I just want to encourage you to go back and read what Henry didn't mention, probably because he's too humble to. The Watergate Special Prosecution Force wrote an excellent closing report in which they detailed all of their investigative work, the way they went about it, and this moment, the Saturday Night Massacre, the firing of Archibald Cox, and how the office endured that and recovered. You should read it. It's an excellent piece of historical work, and it doesn't get enough attention.
If I can tell you all the phenomenal library at Berkeley Law, they have the first final report, a strange name because there's a second final report.
Go look at it, and I got to tell you, I read it when I was the Deputy Special Counsel, and it was actually hard to find. I hate to tell you that, but it's great that it's here in the library. Go get it. But in any event, just stepping back briefly for a moment, right? So Donald Trump, we're dealing in the 1970s during Watergate. It was a Watergate break-in of an office. The president lied about it and tried to cover up his knowledge or involvement in it. A startling crime, a really startling crime. Contrast that with the severity of the allegations against Donald Trump, the first president in American history to ever attempt to interfere with the peaceful transition of power. And then after failing that, leaving the White House with some of the nation's most sensitive secrets and locking them in a closet at a resort in Florida. I, for one, think that the allegations and the crimes committed by Donald Trump, they are much more gravely serious than the allegations against Richard Nixon. And now contrast the levers of government and the public. First, the U.S. Congress. The U.S. Congress worked with bipartisanship to conduct an investigation of Richard Nixon to ensure that the special prosecutor had the resources and the independence necessary to conduct a thorough investigation. Contrast that with the reaction of the U.S. Congress and the allegations against Donald Trump, and the way in which it divided Republicans and Democrats. Second, the court system. As Henry noted, one of the biggest moments in the Watergate investigation was the subpoena on Nixon to obtain the tapes of the recordings of conversations in the White House. Judge Sirica moved with alacrity to make a decision on enforcing that subpoena. I will say this is where nothing has changed in the District of Columbia. The District of Columbia judges acted with alacrity in the Trump and the January 6 investigations and throughout. But that is where the parallel ends. After Judge Sirica decided that Nixon would have to comply with the subpoena to turn over the tapes, that decision never got reviewed by the DC Circuit. And that is because the Supreme Court actually granted cert before judgment and plucked that decision from the circuit court, deciding that it was so important that it be resolved, this subpoena upon a sitting president, that it needed to be resolved and be resolved quickly and decisively. And they did. And in a matter of weeks, the Supreme Court enforced that subpoena. Contrast that with what happened in the investigation of Donald Trump after the immunity decision by Judge Chutkan, the district judge in DC. It was months before the Supreme Court ever got to that case. And yes, that is more quick than many decisions occur, but it pales in contrast to the alacrity with which the court operated in the Watergate era. Third, the public and the media. And just to boil it down, like Henry said, there were 50,000 telegrams after the Saturday Night Massacre. There actually, if you step back, I believe that there were actually 400,000 communications to the White House and to members of Congress by members of the public saying, what just happened when Richard Nixon fired Elliot Richardson and Bill Ruckelshaus? In this era, and one other example of the public, and then I'll get to reminding everyone what happened here. A few years later, when Gerald Ford ran to be returned to the White House, he succeeded Nixon after Nixon resigned. He was denied the opportunity to return to the White House by the United States public, and many historians and political scientists agree that the decisive factor in his failure to obtain election was that he pardoned Richard Nixon, because the public could not stand the notion that any person would stand above the law. Here, after the allegations against Donald Trump, Americans returned him to the White House. Just a remarkable contrast in public consciousness between 1976 and 2024. And finally, what I just do want to note, and then I think Molly's going to talk a little bit about the special counsel, is a remarkable difference in leadership. And I don't want to make any of this personal or anything like that, but if you imagine now in 2025 or 2026, I'm sorry, the president giving a directive to the attorney general or to the deputy attorney general, and Elliot Richardson and Bill Ruckelshaus had the courage and the principle to stand up and say no and resign their positions. Pam Bondi is no Elliot Richardson, and Todd Blanche is no Bill Ruckelshaus. The difference between these two eras is remarkable, and I think speaks to the national condition and where we stand now.
Hi, everybody. My name's Molly Gaston. I was until January of 2025 a career federal prosecutor focusing on public corruption, and I worked with JP in Jack Smith's office. My focus was the case based in Washington, D.C. Into President Trump's efforts to overturn the results of the 2020 election. So the first contrast, I want to add one contrast to what Henry and JP were just saying that is outside of the special counsel's context. But when you hear the term the Saturday Night Massacre, hopefully all of you were familiar with that before now, but now have heard about it from Henry. But I want to refer to something that JP and I have, between the two of us, referred to as the Thursday Night Massacre, because shortly after the Trump administration took office and the Trump Justice Department started its work, the political leadership of the Justice Department directed prosecutors in New York to dismiss the ongoing prosecution of Mayor Eric Adams. And the appointee in the New York, the Southern District of New York, that U.S. Attorney's Office that had that pending prosecution was a Republican appointee. She had been appointed by Donald Trump and was expected to go through the confirmation process. And she refused to dismiss the case because she could not see any appropriate reason to dismiss it, and that it was not in the interest of justice to do so, and she resigned rather than dismiss the case. Others in her office also dismissed the case. The political leadership of the Justice Department then directed lawyers in the public integrity section in Washington, D.C., which somewhat ironically was created in the aftermath of Watergate to handle politically sensitive cases without any regard for political interference. That section was then directed to take up the case and dismiss it, and the leadership of that office refused to do so and resigned in protest. Ultimately, an individual agreed to dismiss the case, and the DOJ moved to dismiss it, and after some litigation, the judge presiding over the case reluctantly allowed the Justice Department to dismiss it. But I think the contrast that one sees there is that there is very little political awareness that happened. There is no outcry that the political leadership of the Justice Department is making its decisions about cases on a political basis rather than what is in the interests of justice. And that is part of the erosion that I think we have seen since the Watergate era in the public's awareness of public corruption, both on a large scale and a small scale, and their ability and will to protest it when the government is refusing to do what it should. Now, one thing I think that is worthy of a discussion is what the best way for the Justice Department is to handle politically sensitive investigations. So in the Watergate era, there was the Watergate Special Prosecution Force. That was not something that was created through some formal process by DOJ. It was really created by people at the Justice Department understanding the gravity of the moment and creating a structure in which the Special Prosecution Force could do its work without any political interference. But in the aftermath of Watergate, there was a statute created that was called it was a statute to create an independent counsel. And the idea was that this would be an entity that could be sort of pop up to handle these kinds of very sensitive prosecutions of the most powerful. And the way it worked was the Attorney General determined to appoint a special prosecutor would inform a 3-judge panel in the District of Columbia, and that 3-judge panel would appoint someone. And you may have heard some examples in history of those independent counsel investigations. One was the Iran-Contra investigation. Another was the investigation of Whitewater. But for various reasons, and some of them were sort of political disagreements over whether this was an appropriate structure, especially with the independence that the individual who stood as the independent prosecutor had from the Justice Department, that statute was allowed to lapse in 1999. After 1999, Congress, there is a regulation, the Special Counsel regulation, and that's the format in which Jack Smith was appointed. It is not as independent as the Watergate Special Prosecution Force or the independent counsels were in the pre-1999 era. The way the Special Counsel regulation works is the Attorney General, when he or she determines that there is a matter in which there is an appearance of a conflict of interest by the Attorney General or the Department of Justice, or it is just some sort of extraordinary circumstance, the Attorney General can appoint a special counsel. It has to be somebody from outside the Justice Department. It can't be a person already working at the Justice Department. And the special counsel has a degree of independence in his day-to-day work, but at the end of the day, he does report to the Attorney General. And if there are disagreements between the special counsel and the Attorney General about an important investigative step that the special counsel wants to take, then the Attorney General can overrule the special counsel, but has to inform Congress that the Attorney General has done so. I think it is worth discussion whether the special counsel regulation does in fact sort of inspire confidence in the public that the special counsel is acting independent of the Attorney General who has appointed him or her. Because I think one thing that we experienced a great deal in the special counsel's office under Jack Smith is Jack Smith is not a political actor. He does not have a political bone in his body, but we were criticized constantly for acting in a political way when we were not. And so I think I just threw out a lot of sort of different formats, but I think we all need to think about the best way to inspire the public's confidence that the individuals conducting these prosecutions are acting independently and on a nonpartisan basis.
Thanks. I'm Donald Sherman. As was said, I'm the president of Citizens for Responsibility and Ethics in Washington. We're a nonpartisan watchdog group that focuses on ethics and accountability. I think if I leave you with anything here, and I'll start with that, is the law does not enforce itself. I'm sure you're getting these questions when you go home to your families, over break. This is illegal. Why isn't anybody doing anything? It is a question I get often. And I think this is the thing that you need to tell them and to continue to tell yourself as you move throughout your career. And I think it's a testament to the public servants that are sitting on this panel with me. The law does not enforce itself. I think the question that Crew and others in civil society have had to face over the last 10 years is what happens when these other institutions fail. A clear example of this is in the aftermath of January 6th, when Mitch McConnell was pressed on why he voted to acquit the president for inciting the insurrection, which we all saw on TV. Some of us saw a little bit closer from our homes. And his answer was, there's courts and criminal prosecutions and, there'll be some other stuff. Somebody else is going to enforce the law. I think for me, running a legal team at a small nonprofit organization, that was one of our first thoughts. The law is not going to enforce itself. Someone has to do it. And as we looked at the Constitution, we brought in the first Trump term the emoluments suits against the president, which are the conflict of interest provisions that were so important that they were enshrined in our founding document. And in the aftermath of January 6th, we looked at how do we hold the individuals who betrayed their oath, as Henry mentioned, and were involved in this insurrection. And the Constitution provided an answer. That was Section 3 of the 14th Amendment, which had not been litigated in over a century and a half, and was an amendment paid for in blood by our forebears in the aftermath of the Civil War. And there was this tool. And the question was, how are we going to enforce the law? And this is a question that we continue to ask ourselves on a daily basis, particularly when Congress has abdicated its Article I authority to legislate, to maintain the power of the purse, to conduct oversight, as the Justice Department, as public servants are forced out of the Justice Department, as civil servants are forced out of other agencies, which is the basis for the lawsuit that Catherine mentioned that my team is leading. But how do we use the tools available to hold, to defend the law, to defend the Constitution? And so we litigated Section 3, first in New Mexico, where we held a trial and secured the first removal of a elected official from office under Section 3 of the 14th Amendment in 155 years. And then we decided, well, we did that. That was challenging. let's go big. And we brought a suit against President Trump in Colorado, which we litigated in 8 weeks up through the Colorado Supreme Court, and then to the United States Supreme Court, where we were promptly curb stomped by the 9 members of the court. But I think as I reflect back on those cases and I reflect on this moment, I think I come back to the same question. Who is going to enforce the law? And if it's not going to be Congress, and it's not going to be the Justice Department, then it's those other pillars that Henry mentioned. It's incumbent upon the public. It's incumbent upon us. And it leads to very difficult and challenging conversations because, as you all are no doubt learning, sometimes the law is not built like that. Standing doesn't work like that. One of the fundamental challenges of being in civil society right now is that there are some statutes that are on the books that have no enforcement mechanism because it was designed that Congress would exert itself, or the government would enforce the law. And so one of the challenges that we face is how to figure out arguments to get in a court to enforce the law. And I think one of the sort of searing challenges of this moment is how many ordinary Americans, how many regular folks like the 6 Republican and independent voters in Colorado that we represented, how many regular folks have to risk their lives, their livelihoods, their reputations to stand up to a lawless president. But this is what it takes in this moment, in part because, our democracy is built on pillars, and a couple of them are broken. And the only way to build forward is for the pillars that remain, the public, civil society, to overextend, to be perfectly honest with you, which is what we are doing every day, working with partners, working in coalition to figure out new and creative ways to use the law, how to push back on the president's corruption, how to defend civil servants. But in this moment, we are being maximalist so that bit by bit we can build back to maybe when Congress regrows a spine, or some people that want to be in Congress that have spines are actually in a position to enforce the law as they should, to rebuild the civil service at some point in the future where there is leadership that is not openly hostile to independent oversight and nonpartisanship. I mean, we're seeing this with the law firms right now, right? One of the first things that the president did when he came into power was fired civil servants, fired inspectors general, and then he went after the law firms, many of which caved. Even before they were in the crosshairs, they caved, right? Because it's those institutions that are going to be the ones that enforce the law against a lawless president. And so bit by bit, we have to be in this fight to build back those institutions. I'm grateful to the folks on the panel who are doing their part. We are certainly doing our part in the civil service community, but it's going to take rebuilding bit by bit and showing some of these other folks in other institutions that courage pays dividends, that courage is contagious, and hopefully we can rebuild those legs that have been undermined. I'm happy to answer questions about details of cases and things like that, but I wanted to leave you with that because you all are going to be out there facing this question, and I just want you to hold close that the law is not going to do it on its own. There are words on paper, you all have to make them real.
So thank you to every one of our panelists so far, and I'm seeing questions starting to come in, just reminding folks that there is the QR code if you want to share questions. But I want to start with JP and Molly. You worked against public corruption under lots of presidents, actually. And we've talked in particular about two presidents, two notable presidents in history on this topic. But I'd love for the two of you just to talk about how anti-corruption work is not about political cronyism and what it means to be doing this work.
Yes, so we used to have the best job because there is nothing better than being a public corruption prosecutor. We used to joke that it was, we would never run out of business because corruption is everywhere. And one of the most, I won't say that, one of the upsetting things that this administration has done, separate and apart from all of the other incredibly grave issues that we've been talking about, is it has taken a very public and very concerted step back from federal enforcement of public corruption laws. So JP and I both worked in the public integrity section at Main Justice, which is a section of prosecutors who travel the country prosecuting public corruption. And a lot of those cases that section used to do was state and local corruption, because state and local governments have limited resources and expend those resources on the things that the federal government is not going to take care of for them. And so we prosecuted bribery and obstruction and all kinds of crimes on the state and local level to help clean up state and local governments. The current administration has reduced the size of the public integrity section from more than 30 attorneys to 2. Two is the latest number I had heard. And so one thing that I think is important is for the public to understand that public corruption is something real and insidious that affects local communities. Some of the cases that JP and I worked on when we did this work were cases in which a guy at the warehouse on the payroll of the local fire department was taking kickbacks, and that meant that the firehouses didn't have the supplies they needed for the firefighters. Or the official at the local Office of Tax and Revenue who was taking bribes to write off millions of dollars of taxes that should have been paid by bar owners. And these are the kinds of things that affect people in daily life, and that is no longer going to be prosecuted by federal prosecutors. And so it's time for state and local governments to figure out how it is that they can start doing these cases.
Thanks.
I guess I'll just add, I think a big, agree with Molly, being a public corruption prosecutor was just the best job. And I really miss it every day, because holding the powerful accountable is just intrinsically rewarding. An observation that I just want to share about it is I had the good fortune of working in Republican and Democratic administrations as a career prosecutor and working on some very sensitive cases. And what I had the opportunity to observe was real leadership by U.S. attorneys, assistant attorney generals, deputy attorney generals, et cetera, in both administrations. And their roles were not always I don't know if they always even agreed with the particulars of everything that we did on a day-to-day basis. But what they consistently saw their role as was to insulate the career prosecutors from any political influence, any undue influence of the powerful, of the wealthy, of whoever. And don't get me wrong, I mean, I think we've actually, people forget, a president of the United States is entitled to appoint U.S. attorneys and an attorney general and to have an agenda, right? And to pursue that agenda, to prioritize immigration enforcement or gun enforcement or fraud and white collar or public corruption and national security. They can pick and choose those priorities. That's completely appropriate. But in the execution of all those cases, it is so important that politics play no role in that, right? In that there's faithful enforcement of the law. And what I adored about that job is that I worked for all these U.S. attorneys and assistant attorney generals, et cetera, from members of different political parties. But their job, they always saw their job was to separate the political from the enforcement of the law. And what I unfortunately saw at the end of my career was a shift. And it was when Molly and I were at the U.S. Attorney's Office in D.C., and I was supervising the Roger Stone case. And that was the case where the president, after career prosecutors made a sentencing recommendation, the president of the United States sent out a tweet saying, that is way too much time. And the attorney general at the time, Bill Barr, reversed the career prosecutor's decisions after it had been filed with the court. But what's happened is, I think as a public, we've begun to accept that a little bit more. And turn our eyes to it, turn a blind eye to it, or at least accept it as commonplace. And so my experience as a corruption prosecutor really shifted over time. And I'm glad to say, in my work in Jack Smith's office and subsequent to and on January 6th cases and whatnot, politics played no role in anything that we did. That's exactly what members of the administration did, was try to block any undue influence and things like that. But I note that now, that big difference and the loss of, I think, perspective, loss of experience of career prosecutors, people like Molly working on these cases, but then also, I think, a loss of perspective amongst political leadership now as time has shifted, and I think as the public's attitudes towards public corruption and the way leaders will supervise these cases approach them.
Henry and JP, you both talked about what it meant to have a massive influx of public opinion coming into the White House, coming into the Western Union office in D.C. to push for change. And Donald, you've given us a really powerful call to action in this room for how we should be using the levers that we have outside government to push against public corruption. We have a question from the audience asking for what are some practical ways that average Americans can contribute to that effort. And so we're looking for some practicality. I'm going to start with you, Donald, because you're thinking about it every day, but I'm hoping that each of you all panelists can offer some ideas responsive to that question.
So again, I think it goes back to what Henry said, but it's not just sort of the public in a generic sense. We need to be citizens, right? We need to be more engaged with each other, with the news, and but you ask for practical things, right? So I would tell, for example, you go home and wherever that is, and your family member says, well, why is the president doing that? That's illegal, right? I think the next part of the conversation has to be, well, yeah, who's going to stop him from doing that? Have you called your member of Congress? Have you called your senator? What have you done to sit with that, right? The benefit that the public has, that citizens have, is that there's a lot of us. That's really the only advantage that we have is scale. Just the fact that y'all remember those numbers, right, says something about the significance of what public sentiment means. I think too often we've gotten to the place where we assume that, well, everybody's corrupt, or we're willing to sort of tolerate a certain level of corruption. And tolerate, doesn't mean that we necessarily like it. It means that we don't dislike it enough to do something, right? So do something small, and then maybe do something bigger. Or the small things that you do collectively become big enough, right, to have a meaningful impact. Members don't like their offices being flooded with calls. And the call systems, I worked in the House and the Senate, they're not that sophisticated, right? You get enough calls, all of a sudden you can't use the phone, right? That's something that gets reported to the boss. They get a breakdown of who comes in, who says what, where their constituents are, upset. And as I have learned, you can't gerrymander a state. And so, I think like engagement has real impact because it stands out. So I think that's one practical thing. I mean, the other thing is use the tools that are available to you, right? We're sitting in one of the best law schools in the country. There are tools available. There are opportunities to write amicus briefs, right? To just to elevate other people's work, right? I mean, you can follow us and share our work, tell people to apply to us. We hire interns and fellows and all that. But there's so much dynamic legal work being done right now, frankly, because we sort of have to figure out ways to dust off these old parts of the Constitution that were designed for a moment such as this. And so I think those are a couple of practical things, right? Do what you can, however small. And it may look different for you all having the privilege of going to school here than it is for your friends or family back home. But everybody can do something, and if nobody does anything, it will continue to get worse.
Can I add one? Oh, go ahead, Henry.
I
Sorry.
just wanted to add one simple word, which is vote.
That's all you're going to give? We got nothing else out of that?
Well, the statistics are overwhelming of those that don't vote and have an opportunity. So I think that's one thing you can do. That's a very good way of expressing, and it has longevity. A phone call may influence a representative, but there's longevity to having representatives that represent the views you want enforced.
What I was going to add is two things, because I can't get out of here without saying it, because I have to do these things now. But I'm running for Congress. That's what I'm doing, which I never would have done before. But we need people to stand up and do it. But the second thing is, what I would really encourage, practical advice, very practical advice, is have the hard conversation. Mm-hmm. We don't have the hard conversation anymore. And I've got 3 high school kids, and they don't have the hard conversation in school about whether it's about January 6th, about whether it's just politics now and policy. And when I say this, I'm not trying to give the advertisement for work that Molly and I have done, but, last year, the president pardoned Henry Cuellar, a Democrat, on a corruption indictment, a startling corruption indictment that Molly and I happened to work on the case. And I'm not here to try Henry Cuellar outside of a court. He was entitled to go to trial and for the government to prove charges against him beyond a reasonable doubt. But he was pardoned on these charges, and the House Minority Leader, Hakeem Jeffries, actually took to the airwaves to praise the pardon and criticize career prosecutors who worked on the case. And that's because it's a very narrow majority in Congress. And Representative Jeffries was trying to maintain 1 seat in Congress, right? And the hard conversation that Molly and I wrote about was, that's not a way to play politics. That is just not a way to play politics. People can have different views of cases and things like that. They can have different opinions and whatnot. But targeting career federal prosecutors, whether you're a Democrat or a Republican, to try and curry favor to hold on to a House majority or come close to a House majority is not good politics. It's disgusting. I mean, the gravest is the president's pardon, right? But the point is, that's a hard conversation. And what I noted is, or what we noted in our piece, is that Democrats weren't having that conversation. I didn't see any Democrats stand up and say anything to the minority leader about that. You got to have the hard conversation. And when you have the hard conversation, it can make a big difference. That's a hard conversation in Congress, but that's a hard conversation at our dinner tables.
The last thing I'll say is I hope that all of you who are currently studying to be lawyers will consider the civil service in the future, because it has suffered immense casualties in the last year, and we need the very best to go back and rebuild it, and you are the very best.
Okay, so on that, somebody in the audience asked, what are the tools that are the specific types of skills and experiences that law students and early attorneys should focus on if they ultimately want to be equipped to work on public corruption issues? So give us some practical advice. Recognizing time, I'm going to ask you that question and also ask you, what is it that you want attorneys and not attorneys to be doing? What do you want us to take away from this conversation? So Henry, we'll start with you.
Well, one is, if you look at the percentages, and Dean Chemerinsky works with the folks that put out the transcript. It's, I think, quarterly, I'm not sure. But one of the pieces of data he puts out is the percentage of Berkeley Law students, and I'm well aware of the costs, having my daughter just have gotten out of Columbia School of Business, the cost of higher education. But the statistics show that the overwhelming percentage of students that go into what I think is commonly known as big law is near 90%. So being a civil servant has consequences, but if you can figure out how to afford doing it, it's something to think about as a career.
I would say, if you're interested in it, is related to having the hard conversation, is don't take the guided tour from anyone, right? Like, we need really independent-minded, strong-willed people pursuing all of these positions, whether it's combating public corruption, working in the civil service, doing our part and whatnot, and everything you can do to make yourself a better critical thinker, more independent-minded, and more prepared and courageous to have like the difficult conversations and not just like take the guided tour. I think the better off you'll be, and the better off we'll all be.
So I think that practical experience wherever you can get it, if in your summers you can work at the local prosecutor's office or intern for a U.S. attorney's office and really get a sense of what the work is like.
Law school teaches a lot of things. It does not teach you how to be a lawyer. Go get skills, real skills with real lawyers who are grinding it out. Public defender's office, clerkship, find the right firm, like whatever the case may be. But having those skills will never serve you poorly, and it's hard to go back and get them, right? So, whatever your first step is, go be a real lawyer and get some skills, and then use your skills and talents as best you can to meet the moment that we find ourselves in.
I had one more to add, and I want to give a shout out to Sue Schechter, who runs the pro bono placement program here. Many of her placements are in the government sector, and she's very well connected and works very hard to put students where they'd like to be.
So we have 3 minutes. And Molly, you mentioned a little bit about what's missing now and the various options for what the law could be governing how we operate public corruption. Someone in the audience has asked us, assuming that at some point in the future we have a Congress with a backbone, that's the words of the questioner, what are measures that Congress could take to prevent levels of corruption that we are seeing now and to reinforce ethics and responsibility? So if you were writing the law that you would want, what would you want it to be? You've got 3 minutes. And don't point fingers at your colleagues.
No, I mean, look, the two things. One, serious campaign finance reform to get money out of politics, eliminate super PACs. That would have a huge downstream effect on corruption writ large. But second, in the civil rights context, we have a private right of action to enforce people's civil rights. There is nothing like that in the anti-corruption context to enforce the honest services of public officials. We have a right, we all have a right for our public officials to be free of the influence of somebody paying them in their official decision-making. Shouldn't we be able to enforce that the same way we enforce our other civil rights? That's another thing that Congress could do.
Well,
Go ahead.
no, Donald, you go.
Hey, well, let me double click on that as somebody who, again, is wrestles daily with, yes, that's illegal. What do we do about it? More people need more standing to get into court. It is the most significant hurdle that we face. Listen to your Civ Pro professors. And we need Congress to have the foresight to envision a world where maybe they are spineless, and to at least create a legal regime where more people with actual spines can get into court to litigate to enforce the law if they choose not to for whatever reason.
Well, I'm going to go back to vote, because I think that's a power we all have if we exercise it. The Supreme Court decided some years ago, and I can't give you the date, I'm sure you all know better than I, Citizens United, the ability of corporations to give money as if they were persons. So one of the connections is the Supreme Court. That's connected to being not only nominated but approved by the Senate. And so who we elect as our officials makes a big difference, all the way up to the court.
Thanks. Close us out, Molly.
I second, oh, thank you. I second JP's call for a private writ of action in the corruption context.
Well, I thank you all for coming today, and also I thank our panelists for their service to the country, their service inside and outside government to the country, and for the reminder that each of us has agency in protecting our democracy. I really appreciate that as a message for today. Thank you all.
Thank you.